At 5:30, North Carolina court says that a mother of a student who was killed in a ride-along can continue suing a trooper for negligence. Well, the incident happened back in 2020 in eastern North Carolina, and reports show that Trooper Omar Romero Mendoza drove off a Pitt County road during a high-speed chase, traveling more than 100 miles per hour, and then eventually struck a utility pole and two trees. Well, 22-year-old East Carolina University student Michael Higgins was inside the cruiser and died. Higgins' mother, Lisa, sued both Romero and also the trooper Brandon Caesar Cruz in 2022. Now, Cruz suggested to her son that he ride with Romero when Cruz lacked the time to do so. Well, Higgins had previously participated in two other successful ride-alongs, but actually neither Romero nor Cruz held the rank of or title to actually complete one of these ride-alongs. Well, Superior Court Judge William Wolf dismissed the lawsuit in 2023, but a state appeals court reversed the ruling. So let's bring in Chief Legal Analyst Clive Rhodes to this conversation. So the first question I have for you is, why then is the mother allowed to continue to sue for gross negligence if this case has been now taking a turn?
Appeal. I mean, so it was dismissed originally. She brought the claim in 2022. Incident happened in 2020. The district court judge, Superior Court judge, I should say, dismissed the case. You can dismiss the case for a number of reasons. Lack of a cause of stating a claim, because this is a negligence claim, and so because it's a negligence claim, you have to state a claim. You can also have it dismissed because you filed it in the wrong venue. Multiple reasons. The lower court believed that they had some type of immunity, and this type of claim could not be brought against the officers. Well, she appeals. Her attorney appeals. They go to the Court of Appeals. I know the three judges, all three of those folks that listen to this because the Court of Appeals, even though it has a number of judges, when they hear these cases, they're broken into three judge panels. Judge Gillen, he dissented. He did not agree that this case should have go forward. He believed that the original judge in the Superior Court made the right decision. The two other judges, Collins and Arrowwood, John Arrowwood, is right from Charlotte. I've sat with him and listened to his thought process a number of times. This case, he said, came down to a couple of things. Because he sped, and the speeding exemption that allows officers to speed and do these pursuits doesn't protect him or give him an extra protection to allow him to avoid prosecution. And Dillon, when he dissented, he said that while I do believe that the officer was negligent, the standard, and I agree with his rationale, is gross negligence. He was just negligent, but that he did it with some type of malice. That not only was I negligent, but I was attempting to cause some additional type of harm in addition to my negligence. The other two judges believed that not only was he negligent, but that he was grossly negligent, and that there was an issue of material fact. So much so that this case needs to go in front of a jury. And I got to make sure I clear that up for you. A lot of times these cases are dismissed, and the jury, me and you, don't get an opportunity to go sit in a box of 12 people, and make a determination, because a judge will dismiss it if they can't get past this part. All today's ruling did was allow it to go forward so that a jury will be able to make a determination of whether or not they should be held liable.
Okay, there was a lot of information in this. I just want to make sure that we're all on the same page. So you have one person, a student, who goes on a ride-along. He's had two successful ride-alongs before this happened. And this one, obviously, it was tragic. Do you think his mother has a case?
100%. Some of the things that they listed today in the judge's opinion, or the Court of Appeals opinion, is a couple things. First of all, that the other people didn't have the rank. So they're pointing to their own internal policies and saying that you guys failed to follow your internal policies. That's normally the first thing you go for when you're bringing this type of claim. The second thing is you go to their recklessness or their disregard for doing anything. He was at one point going 111 plus miles an hour. Again, this situation was extremely unfortunate, but when they look at the deposition, when you go through all of the stuff that happens before you go to trial, a lot of it is pointed to there will be some liability on the officers. That's why you do everything you can to get this tossed before it gets in front of the jury.
Wow. So much emotion tied with this case, too. Clive Rhodes, appreciate your insight as always.